Lawrence's deposition was scheduled for March 11th. We had a conversation with her before that to tell her what that entailed, and that is when she disclosed the comment about the wrong way signs. I absolutely recall telling the defense counsel, disclosing that orally to defense counsel, because as I wrote in my motion, it's triggered a conversation about how the media had done a piece shortly after this incident to determine whether or not there was sufficient signs to keep wrong way drivers off the interstate. So I am absolutely positive that happened. I have absolutely no doubt in my mind that conversation happened, and I disclosed it. I did not disclose it to Dr. Kapoor because she was no longer our witness, and my assumption was that the defense would disclose that if they felt it necessary, and that was their decision to make. And then, again, the morning of the deposition, they canceled Mrs. Lawrence's deposition, and here we are. My understanding from Ms. Lawrence is that they never met with her before her testimony to go over her testimony. Meaning, and as the defense just stated, they know that she had talked to him. She had talked to the defendant over 100 times since this case has come through, and didn't meet with her or ask her whether or not the defendant had talked to her about this accident at all, these crashes. We assumed they had all of this information and were making a strategic decision not to depose her. And again, there was no reason from our perspective to have believed they didn't have that information. And as to the wrong way signs...
So can I just on that, so the defense was aware before the defense put Anila Lawrence on the stand that she had had ongoing conversations with the defendant for the better part of a year. You didn't have the content of those, but you knew that she had ongoing conversations with Mr. Bourgoin.
We knew that they had spoken after the accident, yes. We knew that they had had conversations. Early on, when Ms. Lawrence, that's during the same period of time that she spoke with Ms. Kiley, and we took the interview in November of 2016.
Okay, it just, to put on an important, wait a second, to put on an important witness like this, knowing that this witness had had ongoing conversations with the defendant a year after the fact, to not want to investigate what those conversations were, I'm just struggling with that. Because you were proffering this witness. You made the tactical decision to put this witness on the stand and to take a chance that conversations, that somehow statements would not come out. I'm really trying to wrap my head around that.
Well, certainly if we had known that she had disclosed a conversation about the post-crash event, it would have changed our calculus, Judge.
But a deposition would have revealed that as well, correct? A simple question, have you had conversations with the defendant since the accident? Can you tell us what the defendant has told you? That would have all come out on a deposition.
It may or may not have. We may not have asked that question. I have routinely avoided asking that question in deposition. I don't know whether the state would have asked that question or not.
Okay.
Whether it would have come out or not is unclear. Judge, it's not our obligation to
I understand.
disclose this, and we can certainly make a tactical decision based upon the information that we have. We have other sources of information that we can use to make a calculated decision about whether that's really a risk or not. And we did. We are, if Ms. Lawrence is kind of to be believed, out of these hundreds of phone calls, there was one conversation that included one piece of information about wrong-way signs. So it's not like she said, oh, we talked about this every night, and And he told me all about what happened and didn't happen. So I think that our belief that there was little risk here was well founded. I just have 1 second, Your Honor.
Okay, but Ms. George, I think, still had the floor.
And, oh, I'm sorry.
Well, I just wanted to add, Your Honor, as to prejudice, the comment about the wrong way signs from the state's perspective is, again, not inconsistent with statements the defendant made to experts in this case, and one in particular to Dr. Rosmarin that I imagine will come out today, about knowing he was going the wrong way on the interstate. So I feel like this motion is based on that one piece of testimony, but it's about to come out in other ways through all of these other experts that the defendant made to them and the defense obviously has had. And again, just back to the deposition, the state absolutely would have brought that information out in the deposition. And the state and defense took over 100 depositions in this case. They deposed everybody that was listed as a witness. They were very diligent in that. There were so many depositions where the parties discovered that there was evidence out there that we did not have, or we had and they did not, and we quickly moved to get that information to them. The one witness that they did not depose is the one witness they're now saying they didn't have evidence for. That's incredibly frustrating from the state's perspective to be accused basically of not giving them that information, which benefits us in no way to have kept it from them, and is baseless based on every other thing we've done in this case and all of the discovery practices that we've had in this case being nothing but an open book, making sure they have everything that they need.
Okay. Did you want to say anything else?
Judge, I would add that Mr. Bourgoin actually had a condition of release not to discuss the case, aspects of the case with Ms. Lawrence. So that is something if he abided by, there wouldn't have been anything to worry about. The idea of a oral disclosure of a defendant's statement is not something that has happened with me in the past. Everything is always in writing. I think the rule contemplates that it would be in writing. I've had prosecutors.
Can you show me that?
In Rule 16.
Okay. Yeah, I'm looking at 16A2. A1 and A2, and it indicates disclosure. I'm trying to figure out where it's written disclosure. I mean, certainly a careful practice would be a cover letter with every disclosure.
At the end of that ABCD, if you go down to the end, it says, if no request is made, the prosecuting attorney shall at or before the status quo in writing the foregoing items or state in writing that they do not exist. I understand that that's the place where they talk about it in writing, and I think that is this ongoing discovery obligations of the state. So again, they're not done just by, they did that in this case. They gave us a long list of things in writing at the time of the initial disclosure, but there's a continuing duty to do that, and I think that applies. There's a continuing duty to disclose this information in writing.
I know there's a continuing duty to disclose, and they're saying they disclosed. You're saying they didn't disclose. So I'm sitting here with 4 attorneys that I trust tremendously, who I think are incredibly ethical and who I think, to the best of their abilities, abide by discovery obligations on both sides, and you're asking me to make a call on that, which is what's frustrating for me.
And that's why it should be in writing.
think the rules sometimes contemplate a perfect world. They contemplate a world where no one else has a case except this case, that all things being equal, everything would be done dotting the I's, crossing the T's, and we all know that no one exists in that world. Both the state's attorney's office and the defense offices are frankly overwhelmed at times with the number of cases and the number of serious cases, and parties do the best they can. And I know the public doesn't understand that sometimes, but I understand that. Take a recess. Does anyone want to say anything else in connection with this?
No, thank you.
No, Judge, thank you.
about whether there has been a discovery violation. And the defense cites Brady versus Maryland, which is the seminal case on the prosecution's discovery obligations, and Rule 16. It's clear when one reviews Rule 16 that Rule 16 not only embodies the protections of Brady or the requirements of Brady, but it adds more. Vermont is a jurisdiction that supports wide open discovery. Certainly on the part of the prosecution, and somewhat more limited, but obligations of discovery on the part of the defense. So under Rule 16A, which outlines the prosecution's obligations, there's no question under A1 that the state has to disclose to defense attorney as soon as possible names and addresses of all witnesses known to them, permitting defendant's attorney to inspect and copy or photograph relevant written or recorded statements within the prosecutor's attorney's possession or control, any written or recorded statements and the substance of any oral statements made by the defendant or made by a co-defendant if the trial is to be a joint one. So no one is arguing that the information at issue here is not subject to Rule 16. The state, in good faith, tells the court that to the best of their knowledge, both the CD was disclosed, but there is no verification or track record, cover letter, confirming email, anything of the sort, which confirms that. There's no indication at all that we're dealing with any bad faith on the part of the state, but whether the state is acting in good faith or bad faith is not relevant necessarily to the analysis at this point. When I'm confronted with a situation where attorneys on one side are saying we did it, the attorneys on the other side in good faith are saying we didn't get it, I can't resolve that issue. And since I can't resolve that issue, I can assume for purposes of this analysis that there has been a Rule 16 discovery violation. I have to do that to give the defense the benefit of the doubt. On the other hand, that doesn't stop the inquiry. Even if we have, or even if I assume that we have some type of Rule 16 violation here, I still have to make a determination of whether there was prejudice. Now, what makes this a little bit confusing is the state initially lists Ms. Lawrence as a potential witness, and I think it's been well established during the discovery period of this case that well over 100 witnesses have been listed at various times given the amount of people that were involved in this case. But as we entered trial, the state had made a decision not to call Anila Lawrence in its case in chief, and it was an open question as to whether the state would be permitted to call Anila Lawrence in rebuttal. I had specifically reserved on that issue. The defense made a tactical decision to call Anila Lawrence. They made a tactical decision not to depose Anila Lawrence. And it's not at all clear to the court what kind of vetting, if anything, was done with this witness before the witness was put on the stand. So when the court tries to figure out the prejudice analysis, I've factored the following in. First, that there was no timely objection to the evidence when it came in. I'm not sure my analysis would change anyway, but there was no timely objection at the time. Secondly, given the defense theory of the case, which has been put in front of this jury from jury selection, jury questionnaires, and opening statements of insanity, it's unlikely that the defense would not have called Anila Lawrence, or at least cross-examined Anila Lawrence, if the state had chosen to put Anila Lawrence on the stand and was permitted to put Anila Lawrence on the stand in its rebuttal case. The prejudice that the defense says they've suffered is they may have handled Anila Lawrence differently. And I think I can cure that. And I think that can be cured by allowing the defense to recall Anila Lawrence if they wish to do so. And I think the additional corrective procedure the court can do is if the court is presented with a drafted order from the defense for the Department of Corrections to immediately disclose any recorded conversations between Mr. Bourgoin and Anila Lawrence, that be done forthwith. And if we continue with the trial, if information is obtained in those conversations that would provide the defense with additional impeaching material in Ms. Lawrence, the defense can recall Ms. Lawrence and continue the examination of Ms. Lawrence with that additional information. There's no indication so far that the information that the defense says they do not have will have any impact either on the testimony of Dr. Rosmarin or Dr. Kapoor, and it's not known what impact, if any, the testimony would have on Dr. Cotton. Should the information materially affect those witnesses, I can always reconsider this decision. And finally, what we're dealing with is information that the court absolutely believes could have been discovered by the defense with a reasonable amount of due diligence, because this was the defense witness who had given a statement to the defense investigator, even if it was back in 2016. The defense was going to make a tactical decision to put that relationship in play as part of its case to build the insanity defense, and I think that still is the state of the evidence. Even if Ms. Lawrence had stopped cooperating with the defense, this is why we have depositions. And we have the right to take a deposition to expose not only information that would be helpful to the defense theory of the case, but the point of the deposition is also to expose information that could be hurtful, so that the defense could then make a decision, or the state could make that decision, as to whether they would put her on the stand. So the defense made a tactical decision to not use a discovery tool which the court believes could have easily led to the information that's at issue here. With tactical decisions, you live with the consequences. And I think that's what we're presented with here. So for all of these reasons, I am denying the defense motion for mistrial at this time. So, is the defense prepared to call their first witness? And if so, I think the jury's been ready since 8:45.
Judge, I would respectfully request a different remedy. And that would be that the testimony of Ms. Lawrence with regard to, at least with regard to the wrong way signs be stricken, and that not be commented upon in the remainder of the case.
The state want to be heard on that?
I'm not entirely sure what the sort of analysis is when coming up with the appropriate cure. I think that's really an issue for the judge to decide.
What I'm understanding is if I'm assuming for purposes of the record that there may have been a Rule 16 violation, the defense is asking for a curative instruction that this is specifically limited to, I didn't see wrong way signs on the interstate should be stricken from the record, and the jury should be instructed to disregard that as a curative instruction.
I think given the ruling by the court that at least as it is to that comment that there could have been, or the assumption is that there was, then I would not object to that instruction.
Okay, so the curative instruction specifically from the defense that you wish me to give to the jury is, one, to strike the statement from Ms. Lawrence's testimony, at least for now, correct?
Correct.
And the specific statement is?
If we have it, we try to get it as verbatim as possible. The first question was, had you talked to him about the event? And she said, no, really, not really, no. So the next question was, is it correct that the only thing he ever really told you about what happened on October 8th was that there were no wrong way signs on the highway? And the answer was correct. So that question and answer, that last question and answer.
So the state is not objecting to the court striking that one statement?
That's correct.
Okay. And further, the curative instruction is that they should disregard that statement and not to consider it as part of the evidence in this case. And any objection to the court telling the jury that?
No.
And then further, that not be, that statement not be inquired upon. Dr. Roseman doesn't know about it, or if Dr. Kapoor or Dr. Cotton were argued in closing, or it's not evidence in the case.
I had no intention of bringing that up with either of those doctors.
All right. So the statement will not be used in cross-examination of the experts.
Correct.
Okay? But the jury doesn't need to know that, obviously. Okay. Does anyone want to say anything else before we bring the jury in?
No, thank you.
No, Judge.
Okay. Can we bring the jury in? be seated. Okay, so first of all, I apologize in advance for keeping you waiting. I think I warned you during orientation that from time to time, issues may arise during the case that I have to deal with and that have to be dealt with out of your hearing. And so, believe me, while you were waiting, we've been working since first thing this morning. I promise you of that. Secondly, before I get to the specific issue, I just want to make sure, over the course of the weekend, have any of you learned anything new about the case or become aware of any information which you were not aware of at the time of the jury selection, but which you now recall which might influence you about the case? Or is there any reason why you cannot fairly and impartially evaluate the evidence in this case and deliver a just verdict? Okay. Counsel, okay, at least with that?
Yes, sir.
All right. Secondly, before we take on the next witness, on Friday, one of the witnesses that was called was Anila Lawrence. And at some point, I think during the end of Ms. Lawrence's, I think it was cross-examination, there was a statement or words to the effect that the defendant had said to Ms. Lawrence that there were no wrong-way signs on the highway. I am striking that statement from the record, and I'm directing that you first disregard the statement, and secondly, that statement will not be part of the evidence for your consideration as this case unfolds. And in my final instructions to you, we'll talk more about the effect of stricken testimony from the record. But right now at this point, I'm instructing you to disregard the statement, and it's not to be considered as part of the evidence in this case. Okay. Mr. Cadams.
Thank you. Call Dr. David Rosemary.
Solemnly affirm the evidence you shall give relative to the cause now under consideration shall be the whole truth and nothing but the truth under pains and penalties of perjury.
I do.
Please be seated. Pull your seat up to the microphone. Speak into the mic.
Good morning.
Good morning.
Good morning.
State your name for the record, please.
David Rosmarin,
And where do you work?
McLean Hospital in Belmont, Massachusetts.
And what's your position there?
I'm Director of Forensic Psychiatry.
What's a forensic psychiatrist?
So a forensic psychiatrist is a subspecialty of psychiatry recognized by the American Board of Psychiatry and Neurology. Involves specialized training. You have to take exams. And it's really where the intersection of medicine and the law, or medicine and psychiatry and the law. So it involves things I don't do, such as expert witness in child custody matters, for example. I don't do child psychiatry. And it involves things I do, testimony and evaluation for legal sanity, competency to stand trial, diminished capacity, threat assessment, suicide assessment. And on the civil side, whether someone's committable and has to be kept in the hospital against their will, whether someone can be medicated against their will, is there a risk of, and then there are other things I do, such as threat assessment in the workplace. So if someone's intimated a threat at the workplace, I often evaluate that person. Or if someone's claiming disability, and there's a question about their disability, or there's a question about their safety to return to work, I do those kinds of evaluations.
Could you please tell us your educational history?
Sure. I attended Colgate University. Major was neuroscience. I briefly attended Columbia and took a couple of courses while I was working in a neuroscience lab. I went to Stanford University in a graduate program in neuroscience. I also went to my first year of medical school there. Then I transferred to Boston University and got my MD from there. Then I did my internship at Boston City Hospital, and I did my psychiatric training at University of Massachusetts Medical Center, where I was chief resident in forensic psychiatry and was a special student at Harvard Law School for my chief residency year.
And could you tell us your work history, medical work history?
Sure. Well, I haven't finished the other answer.
Oh, I'm sorry.
So then I got board certified in psychiatry. Board certification is you take tests, and you have to qualify and you take tests. I became an examiner several years after that in general psychiatry, examining candidates whether they were sufficiently trained to be a general psychiatrist. And then I became board certified in forensic psychiatry. You take an examination every 10 years. And for some years, I was the author of the national exam in forensic psychiatry that candidates had to take, along with a group of other forensic psychiatrists, for the American Board of Psychiatry and Neurology.
Now, with regard to your work history.
So it's a long work history. When I finished my training in forensic psychiatry, I became the director of the women's forensic unit, the medical director of the women's forensic unit in the Boston area. It was at a state hospital. They were developing it. It was the forensic unit for women. There's been long-standing a forensic unit for men, so it was called Bridgewater. This is the women's forensic unit. Within a year, that unit closed because the whole hospital, they shut down the whole hospital. And then I went back to University of Massachusetts for a year. I ran a dual diagnosis unit, which was the unit that evaluated people for mental illness and substance abuse, that kind of dual diagnosis. I was also medical director of Spectrum House, which involved people who had addictions. And I was starting to practice forensic psychiatry in my private practice. Following that, I got recruited to what's now called Harvard Pilgrim Health Plan. It used to be called Harvard Community Health Plan. It's a group of large clinics. My clinic had 25 to 30,000 patients who would get their care at this clinic. Medicine, neurology, surgery, and I was the chief of psychiatry there for, I think, 10 or 11 years. At the same time, I got asked to help start up the program in law and psychiatry at Mass General, so I was working at Mass General 1 day a week doing evaluations there. Then after 10 or 11 years at Mass General and and also at Harvard Community Health Plan, I joined the CIA. I was recruited to the CIA to work in the unit that evaluates the psychiatric aspects of world leaders and others. I would say that I never evaluated a detainee, which is important for people to know. In other words, someone who was, I'd never evaluated someone who was being held against their will. So I was in in various capacities. I was at the CIA for a decade, part-time, while working in forensic psychiatry back in Boston. So I was commuting back and forth between Langley and Boston. That ended, the CIA portion ended in 2010 or 2011, and I've been in the practice of forensic psychiatry since that time at McLean and in my private practice.
Have you had any faculty academic appointments?
Yes, at Harvard Medical School since, I think, 1991, approximately.
And what do you teach there?
Well, what I do now is I give talks on forensic psychiatry. The residents come with me. Every month I get a medical student, and I take the medical student around to examine patients, go over how to examine the patient, how to write up a history and physical, how to make a treatment plan.
Have you, so you've conducted forensic evaluations before?
Probably over 1,000.
And have you been qualified as an expert forensic psychiatrist before?
I have.
In what states or?
In every jurisdiction in Massachusetts, a couple in New Hampshire, and here in this courtroom, and another courtroom down in Newfane.
So approximately how many times do you believe you've been qualified as an expert forensic psychiatrist?
Hundreds and hundreds.
Could you describe your, kind of your current practice, your current work?
Yeah, so I do a variety of things, as I was saying before. I do assessments of competency to stand trial and legal insanity. I consult to two major hospitals, Dana-Farber and Beth Israel, for their occupational health for their employees, which number in the tens of thousands between them, for occupational health issues that arise in psychiatry. Medical director of occupational environmental health work, not medical director, director of psychiatry, sorry, of occupational environmental health network, which again, it does occupational psychiatry questions. Again, mostly doing with disability. Is someone disabled? When they're disabled, are they safe to return? What kinds of conditions can they return under? I do a lot of commitment cases, probably 30, 40, 50 a year, about whether someone's committable, whether they're dangerous to themselves or others, whether they're competent to refuse or accept medications. And I do, well, two in my life, malpractice cases.
So you talked a little bit about you've done some work here in Vermont?
I have.
Okay. And who, so just so I understand it, is that attorneys will contact you and hire you to work on a case?
Yes.
So have there been prosecutors in the state of Vermont that have called you to retain your services?
Yes.
Okay. What counties?
In this county, and in the southwest, I don't remember the name of the county, in the southwest county, Erica Marthage.
Bennington County?
Bennington County.
And so you've been, and how about assistant attorneys? Have there been any assistant attorney generals for the state of Vermont that have hired you as well?
Yes.
And you've worked also for defense attorneys in Vermont?
I have.
Approximately how many times have you worked for defense attorneys in Vermont?
Probably a dozen or fewer over the 30 few years I've been doing this.
You said you were hired by a prosecutor in this county.
Yes.
Is that recently?
In the past year or so, yeah.
And you've worked for me before on other cases, correct?
Yes.
Approximately how many?
Half dozen.
And how does it, with attorneys that contact you to provide assistance on a case, how does, how does that work? In other words, if somebody calls you up, are you then trotted right into court and can testify for them?
So if I get a call, I want to basically understand what's this case about. What do you give me a paragraph or two of what this is all about? Is this within the field of my expertise or not? Is one question I want to know, and then I want to know what I'm being asked to do. Is it insanity? Is it competency to stand trial? Is it a threat assessment? What is it all? Is it a civil case? What is it all about? Then, in an insanity case, is sort of a escalating level of things I do when there's an insanity case.
So when people call you up, are you always able to then testify for that side in a case?
No.
Okay, so how does that work?
Well, I can say initially it doesn't sound like the kind of case I'm expert in, or it doesn't sound like a case that I can render a positive opinion about just from hearing the facts as presented to me. So I'll say, I can't help you in this case. In other kinds of cases, I get more information, or I do an initial examination of the defendant, and I say, well, I don't have anything. I can't help your case, or I can help your case based on the information I have at that stage. Do you have a sense of how many times you're contacted by defense attorneys, let's say, and you're able to either assist them or not assist them? It changes over time, and it changes over time because, and it also changes about the nature of the crime. So in murder cases, there's not too many defenses against murder. You didn't do it, you were coerced, or you're insane. And sometimes there's a question of diminished capacity. So sometimes there are a lot of cases I go and do evaluations where it's a little bit of defensive lawyering on the part of the attorney, and I make it clear that I can't help them. Sometimes it happens mid-stage where you find out something that, oh, well, that doesn't make sense, or that contradicts something, or you find out that the defendant has lied to you. And so it really depends on what stage. Usually, it really depends on what stage and what kind of information you're getting and how the first examination goes.
And in your current practice, what's the proportion of work you do now for defense attorneys as opposed to prosecutors?
Just about all for the defense.
You do have some prosecutor cases?
Occasional.
And how does it work primarily you work in Massachusetts?
Yes.
And how does it work in the criminal context for competency and sanity in Massachusetts with regard to the initial evaluation and who does those evaluations?
Most of the time, just about all the time, the defendant is sent to one of the two forensic hospitals, Bridgewater, which is exclusively for men, or what used to be called Worcester State Hospital, which is now called Worcester Recovery Center, and there's a unit there for men and women. The evaluators at Worcester Recovery or Bridgewater do the evaluations, and for the most part, those evaluations most of the time they're the witness for the prosecution.
If I may approach on, I'm showing you what's marked defendants L for identification. Could you tell me?
That's my CV.
All right. And is it summarize some of the materials we've been talking about, and then also give greater detail as to your background and experience?
Yes.
Your Honor, I move for the admission of defendants L.
Any objection to L?
No objection.
So L is admitted without objection.
Your Honor, at this point, I move that Dr. Rosemary be qualified as an expert in the area of forensic psychiatry.
Any objection?
No objection.
Okay, the court will find him so qualified.
So what's your kind of standard methodology in a case where you're being contacted to do a sanity evaluation?
The first thing I do is speak with a lawyer and ask for some of the basic facts, and then there's sort of two pathways. One pathway is if it's close in time to the crime. If it's close in time to the crime, I want to get to see the defendant as close in time to the crime as I can to see what their mental state is, to memorialize their mental state in a video, generally for the serious crimes. I'll ask to be able to videotape my exam, and I'll want some background information. So there's a sort of inverse relationship, a balancing point. So if it's close in time to the crime, I'll want, at a minimum basis, the police reports, like what are the basic facts here, what is alleged. If it's further in time from the crime and it's not as much of an issue of me memorializing their mental state close in time to the crime, I'll try to get more information so I have sort of more background information about the person for two reasons. I want to understand the person, and the more information I have, the more I can have my ears open for if they're lying. And sometimes people lie to me.
Why do you videotape? Or video record, I guess.
Yeah, video record. So I think that in serious cases where the resources are available to do this, that I like to, I believe in transparency. So I don't do perfect examinations. I never claim to be perfect in my skills, but I do the best I can, and it's there. I want to memorialize what I say and my demeanor to the defendant, and what the defendant says and what their demeanor is. I believe it should be, in my personal beliefs, is that it should be open, transparent. There's another issue, which is that then what the defendant says to me, it gets properly transcribed. I don't have to be thinking, asking questions, writing them down, misquoting the person. And I also want to make sure that what I say is available to both sides for the context of what is being said, so that it doesn't seem like what I'm quoting is being cherry-picked to just put up my side. Whatever it is, it is. And it helps the whole process. So if I do an evaluation for the defense, then the prosecution expert generally gets to see the data that come from my examination and consider it as to forming his or her own other opinion, possibly the same as mine. So I just think it's a matter of transparency and fairness.
You talked about people lying to you. Do you know what the term malingering is?
Malingering is the medical term for faking illness for a secondary gain. So it has to be conscious. It can't be unconscious, and some people think they have illnesses and they actually don't. But it has to be conscious, and it has to be for a secondary gain. That is, and it doesn't have to be just, it can be just the exaggeration. It doesn't even have to be yes or no, right? It can be the exaggeration of their illness for secondary gain, such as, in a case like this, pleading insanity. That would be an example of exaggerating or faking illness to be acquitted.
Is malingering something that you watch for during your forensic evaluations?
I do.
Are you familiar with the statutory insanity standard in Vermont?
I am.
And just have one moment, Your Honor. What is the statutory insanity standard in the state of Vermont?
I can do it pretty close to verbatim, or I can read it.
What's your understanding?
It derives from the American Legal Institute Model Penal Code that was promulgated in the 1970s in many states. It says that as a result of mental illness or defect, which is sort of an archaic term, defect, and I can explain that, at the time of the crime, the person lacked adequate capacity to appreciate the criminality of what they did, or lacked substantial capacity to conform their behavior to the law.
I'm going to see how you do. Okay? Showing you the test for insanity in criminal cases when you just testified to correct a person's not responsible for criminal conduct at the time of such conduct as a result of mental disease or defect. So I think you said mental illness, but mental disease.
Mental disease or defect, thank you.
He or she lacks the adequate capacity either to appreciate the criminality of the conduct or to conform his or her conduct to the requirements of law, correct?
Yes.
I want to go through that kind of piece by piece, if we could. So, on this poster board, I've listed it as 2 separate prongs. Is that how it's referred to often?
Yes, they're called prongs, yes.
Okay. And in order for an individual to be criminally insane in Vermont, the person would have to fit both prongs, correct?
Either prong.
Well, prong 1 and prong 2.
Right.
In other words, they would have to have a
Subprong
mental
of 2.
disease or defect
Yes.
that caused them to lack adequate capacity to appreciate the criminality of their conduct or conform their conduct to the requirements of law, correct?
Correct.
So let's break that down just a little bit. You said already, let's start kind of backwards where you started with defect. What is a mental defect? You said it's a somewhat archaic term. So.
Yeah, I mean, there are archaic terms that persist in the way we refer to people, just like no one's referred to as mentally retarded. It's not an appropriate term, right? It's cognitively impaired, right? Intellectually impaired. So that's an archaic term from from the 70s, and defect. The understanding that the history of this is that this is supposed to not be exclusionary. That is, everyone has an idea what's a mental illness, schizophrenia, for example, right? But what are other kinds of things that can impact someone's capacities? And they can include congenital things you're born with, such as lack of intellectual capacity. It can include things such as developing a tumor or having an inflammatory disease of the brain, developing Huntington's chorea, which is a dementing illness as well. So defect is meant to encompass not just the psychiatric illnesses that people are more familiar with, bipolar disorder, schizophrenia, but also other things that can impact the brain. And so I think it's meant as, historically it's been viewed as broadening it, so we're not just talking only about a couple of psychiatric illnesses that are sufficient.
And let me just back up again for a second. I mean, you're using this definition when you're doing an examination for an attorney in Vermont to determine whether or not the individual is insane according to this standard.
Yes.
I mean, are the standards different around the country?
Yes.
So what is, when you're doing your evaluations, how do you define mental disease, and where do you get that definition from?
Well, there's, when the American Legal Institute promulgated these model penal code, and from which this is taken with one slight change, it was using the DSM-1, the Diagnostic and Statistical Manual 1, which basically defines a mental disease as having something that causes suffering or impairment. So it's something that's clinically significant and causes suffering or impairment in things that the mind is supposed to be able to do. And in some states, they let the Department of Mental Health define what a mental illness is, like in my state. In other states, there's a understood diagnosis that, and this is the diagnose, and so these are the kinds of things that are considered when you're asking about whether someone has a mental illness. or mental disorder.
Okay, so I just put up another poster board here, which says definition of a mental disorder. Where does this come from?
That comes from, looks like that's sort of summarized from the DSM-5, our diagnostic, it's the 5th edition of our diagnostic manual.
And so what is the definition of a mental disorder then?
So the first piece is it's clinically significant, causes clinical significance. It's not something that's trivial, okay? And then it talks about some of the capacities that the brain has: cognition, emotions, behaviors, and it causes a lack of function or a dysfunction. And it can be caused by psychological factors, by more obvious biological factors, or it can be developmental. So sometimes people are born. So people, for example, example of a developmental illness would be autism, severe autism. So it tries to, it's encompassing and talks about clinically significant lack of capacities and the things the mind normally does.
And the last part of this says, what's the last piece here? Mental disorders are usually associated with, is that?
Well, distress or disability, as I mentioned a moment ago, right? They either cause you suffering and/or they cause you incapacities.
So, with this case, we're talking about mental, illness, not defect.
Talking about a mental disorder, yes.
Mental disorder. All right, so we made it through first problem here. So, if what's going on is the person doesn't have a mental disease or defect, then they're not criminally insane in Vermont, correct?
Correct.
But if they are, then you would have to still look and go down to see whether or not the person lacks adequate capacity, either to 1 or 2, correct?
Correct.
So let's talk about lacks adequate capacity. What do you, how do you define that phrase, or what do you use when you're looking at whether somebody lacks adequate capacity when you're doing a Vermont evaluation?
So the word adequate is, for me, pretty synonymous with sufficient. Okay? Vermont has, that's not the usual way it's worded in most states that have this American Legal Institute Model Penal Code. Most states talk about substantial. This one is more similar to New Hampshire, which just says you're found insane if your act was a product of mental illness. I always joke and say, well, that's because Vermont used to be part of New Hampshire, pre-Revolutionary War. I don't know where that came from, but it's a that's to me a softening of the standard beyond substantial. It's just adequate. Was it adequate or not adequate? Looks more similarity to the test that they have in New Hampshire, that the act was a product of mental illness, and that's all that the standard says.
So other states, instead of the word adequate, they have lacked substantial capacity?
Most states, yes.
Okay. And if you were doing an evaluation, you would see that as being, in those states, you would see that as a higher bar to meet.
Yes.
So Vermont is more...
Wasn't enough. Your capacity wasn't enough.
Then, again, it's either two. So it could be that the person couldn't do number 1 or couldn't do number 2. It doesn't have to be both, correct?
Right. So if you think of number 1, that's the sort of cognitive prong. And the word appreciate, there's a lot of thought that went into the word appreciate as opposed to know. Appreciate includes an emotional quality to it, a weighing quality, not just merely a binary yes, no, doesn't know, no, doesn't know. Appreciate includes the emotional, what we call valence or emotional quality. It's a softening from states that have the standard of no. In some states in the federal government doesn't have no, but some states have the word no. Appreciate is from the original American Legal Institute Model Penal Code wording. A lot of thought went into that word.
So know, K-N-O-W, know the criminality.
Yes.
Okay. So again, that's what appreciate the criminality of their conduct means.
Yes.
When you're doing evaluation. And then number two, what does that mean to you when you're doing evaluation?
Conforming, so there's two prongs. The first prong is the appreciating the wrongfulness. That's the cognitive prong, right? And the second prong is the self-control prong. That's the volitional prong. And that they lacked adequate capacity to control their behavior.
And again, it doesn't have to be both. It can be one or the other or both.
Correct.
Were you contacted by me to do a forensic evaluation in this case?
I was.
And when was that?
January 2018.
And did I offer to pay you?
Yes.
All right. And what's your
$400 an hour.
I'm sorry?
My rate's $400 an hour.
Okay. And what was our agreement? That I'd pay you for the hours you worked?
You pay me for the hours I worked, and that my payment was not contingent on me saying something that helped your case.
And so what did I ask you to do?
You asked me to evaluate the defendant and come to an opinion about whether he was sane or not sane at the time of the crime.
And approximately how many hours have you put in on this case since I called you? Well, let me stop there. Did you know Mr. Bourgoin
No.
prior to this?
I didn't know of him, and I had never heard about the case.
And so approximately how many hours have you put in on work on this case, not including driving up here yesterday?
Well over 100.
Were you able to review documents in connection with this case?
Thousands of pages.
Were you able to conduct an in-person forensic evaluation?
Yes, I examined him twice.
So based upon that review, were you able to reach an opinion about whether or not Mr. Bourgoin was illegally insane at the time of the offense?
I was.
And so what is your ultimate opinion in the case?
My opinion, with reasonable medical certainty, psychiatric certainty, is that at the time of the crime, because Mr. Bourgoin was suffering from psychosis that was caused by him being manic from the illness bipolar disorder. He had a particular kind of bipolar disorder. He had bipolar disorder with psychosis. He had bipolar disorder with what we call rapid cycling, meaning 6 or more episodes a year. That at that time, he both lacked adequate capacity to appreciate the criminality of, and lacked adequate capacity to conform his behavior with regard to the 3 charges he is charged with, which I evaluated to be the 5 deaths by second-degree murder, the stealing of the police car, and the reckless driving.
And did you come to an opinion about whether or not, during the time of the event, Mr. Bourgoin was suicidal?
I did.
And what was that opinion?
I thought the weight of the psychiatric evidence was strongly against it.
So I want to talk to you then about how did you, in general, kind of in a gross way, how did you arrive at that opinion?
Well, I got an initial batch of records from your office, and then I went to examine him up in Northwest Correctional Facility under videotape. That was the first stage. So first I read these documents, and then I went to see him and examined him the first time for 4 hours.
Is what you saw in Mr. Bourgoin something that is typical for what you see in individuals suffering from the mental illness that you diagnose them with?
Yeah, his clinical course is fairly typical. So I see lots of people with bipolar disorder, including people who aren't treated. So a lot of times people come to our units at the hospital and they're not accused of any crime, but sometimes they've driven in an extremely dangerous way, but luckily no one got harmed. And I see how they are, because oftentimes, unless they're rather immediately threatening in the unit, oftentimes these people are not accepting medication, and so you get to view them over time until we go to court and say this person, requires medication, he's incompetent to refuse medication, the court orders it. So I see patients with bipolar disorder and hear their stories in both legal contexts and non-legal contexts. And so most of bipolar disorder does not involve legal contexts. It involves people suffering, people who get an illness that they never wished to have, and no one would ever wish to have it. It's an awful illness. And so I see both, and one of the things I do is I compare what I understand to be the course of the illness in a legal case with how things are in how things are in non-legal cases.
So you say you reviewed documents in connection with this case, correct?
I did.
Can you lump them into some kind of categories?
Sure.
As opposed to going through them individually, what types of records did you review in this case?
Well, I looked at the batch before the first examination were the charging information from the state, the prosecution's case. And I looked at family court documents. I looked at a prior charge with regard to a domestic assault. I saw medical documents such as toxicology, some UVM records. I saw Dr. Cotton's competency and insanity report. I looked at some of the investigative interviews. Ms. Kiley interviewed Ms. Lawrence and Ms. Fisher, and I looked at sort of corroborating information, FBI reports, discharge from the Army, things like that. That's what I had at the time of the first exam.
Okay. And so did you review more records after the first exam?
Yes.
And have you continued to review records in connection with this case?
Yes.
And again, what types of records have you reviewed?
More extensive UVM medical records, DOC medical records. I looked at Dr. Kapoor's interview videos and read the transcripts from them. I saw Facebook and cell phone reports. I saw a psychological report by Dr. Baranowski. I saw transcripts of depositions by 8 people who knew Mr. Bourgoin. I saw the Howard Center records regarding him. I saw Dr. Cotton's deposition. I read Dr. Cotton's deposition, rather. I saw his arraignment video. I saw the various officers had cruiser videos and body cam videos. I saw lists of the Excel spreadsheet of messages to and from Mr. Bourgoin's phone, depositions, record of calls to his phone. I saw more trooper videos. I saw UVM surveillance videos. I saw
UVM Medical Center?
Yes, UVM Medical Center. I saw depositions by various doctors involved with his care at UVM Medical Center. I saw depositions, or read depositions from security at UVM Medical Center. I saw Dr. Cotton's dictation notes, not the same as his report. I saw Dr. Steingardt's deposition transcript and Dr. Lucas's deposition.
So did you see then medical records, kind of historical medical records of Mr. Bourgoin?
I did.
And you saw medical records from the day of the crash, prior to the crash?
I did.
And then you saw medical records from after the crash?
I did.
And did you get Department of Corrections records for after the crash of Mr. Bourgoin?
1,300 pages.
Primary approach, Your Honor. I'm showing you what's been marked as Defendant's Exhibit M. Can you tell me what that is?
This is the list I was just summarizing.
Okay.
of-
You didn't name everything on the list, though, right?
No.
Okay. So this is a complete summary of the information you reviewed in connection with your opinion in this case?
Yes.
Your Honor, I move for the admission of defendant.
As a summary. Any objection?
No objection.
M is admitted as a summary without objection.
You mentioned a couple of doctors in your, sorry, let me go. So let's talk about the forensic interviews that you did in this case. So how many did you do? That's of Mr. Bourgoin, correct?
I did a subsequent one after the first one.
Okay, so you did two.
Yes.
Okay, and where were those conducted?
Northwest Correctional.
And so why don't you tell me, not about the substance, but tell me about the protocol that you used and the length and kind of the outlines of the first examination.
Well, the first examination, I had a substantial amount of material and then an understanding of some of what happened physically, and I went to examine him, and I started the videotape, and the videotape is rolling when he walks in the room, not after.
And when was this examination?
That was in February 2018. It was February 16th.
And how long was your examination?
4 hours.
And then there was a subsequent evaluation?
Yes, that was in April 2018.
And the same video recording protocol?
Yes.
And were you alone during that evaluation with Mr. Bourgoin?
No.
Who was present?
Dr. Scott Lucas.
And who's Dr. Scott Lucas?
Dr. Lucas is a researcher and toxicologist at McLean, whom I had never met, and I was wanting to get some more detail about some of the toxicology reports and understanding some of the more detailed stuff about the toxicology that I saw in the reports, and from what what Mr. Bourgoin told me. And so I went to a doctor who I knew there, who's also a marijuana researcher, Stacy Gruber, and she doesn't do this kind of thing. And she says, "What you should talk to Scott. He's given marijuana in extremely high doses to thousands of people. He knows this stuff down, and he knows all the street details of the names and the concentrates, because he sees it. It gets brought into his lab. They test it. So I called him up and asked him if he would collaborate with me.
And how long was this second interview?
5 hours.
So, I'm sorry, is it second or third interview?
Second. There were only 2 interviews with Mr. Bourgoin, correct?
Correct.
Okay.
And so you did one interview, you review documents, do an interview, review documents, do a second interview. Do you review more documents and videos and things after the second interview?
Yes,
Okay. Do you then write a report at some point?
I did.
And what's the date of your report?
June 25th, 2018.
Showing you what's marked as Defendant's Exhibit K for identification. Can you tell me what that is?
That's my report.
Okay. And do you have a copy of it there?
I do.
All right. And then after you wrote your report, you just keep working on the case?
More information came in.
So you reviewed more information, videos, of things like that after you wrote your report?
Correct.
Did your report contain the conclusion that you previously told us about Mr. Bourgoin being legally insane at the time of the offense?
That's what I opined in my report, yes.
And have any of the subsequent materials you reviewed changed that opinion?
No.
You mentioned a couple of other doctors, and I want you to tell the jury who you understand they to be. So Dr. Kapoor, who's Dr. Kapoor?
Rena Kapoor is a psychiatrist down at Yale. I know her casually from the American Academy of Psychiatry and Law, and also I came down there and gave a lecture down there, and I think I met her at that time too. She's a good doctor, smart. I've seen some of her academic presentations at the American Academy of Psychiatry and Law, and she was retained by the prosecution in this matter.
And what's your understanding of, did she write a report, do you know?
She declined to write a report.
Do you know why she didn't write a report?
What she stated in the deposition is was she was told by the prosecution not to write a report.
And what was her ultimate conclusion in the case with regard to legal sanity?
That Mr. Bourgoin was legally insane at the time of the crimes.
And you talked about another doctor, Dr. Cotton. What's Dr. Cotton's connection to this case?
He initially was the court-ordered psychiatrist to evaluate Mr. Bourgoin for competency and criminal responsibility a month or two, I think, after the accident. And then he opined that Mr. Bourgoin was both competent and criminally responsible.
And that was his initial connection with the case. Did he have a subsequent connection with the case?
Well, then he was, as I understand it, he had two kind of documents, and the first report that I saw was one document. It differed from his other document.
As far as later on in the case, initially he wrote a report, correct?
He wrote and signed one report, yeah, that I saw.
Okay. And then after that report was written, did he subsequently become involved in the case again?
It's my understanding he was after Dr. Kapoor was opined that that Mr. Bourgoin was legally insane, that Dr. Cotton became the primary witness for the prosecution.
Okay. And he was retained by the state at that point?
Yes.
During your review of materials that you were provided and your discussions with Mr. Bourgoin, did you obtain information about his background and history prior to this event?
Certainly.
And what were the sources of that information?
Well, there are many. What he told me, what he told investigators, what he told Dr. Kapoor, somewhat what he told Dr. Cotton, depositions by people who knew him, medical records that refer back to as early as 2010 when he started treatment with a doctor, I believe it was Jacobs, for anxiety problems. So those are multi-sourced.
And is this important information for you to have in rendering an opinion with regard to sanity in this case?
Sure, you want to know the longitudinal course of how someone is and think about how they ended up doing being involved with such suffering and, such lack of capacity that he ended up having this horrific accident.
And so what did you learn about Mr. Bourgoin through these multiple sources that informed your opinion with regard to this case?
So Mr. Bourgoin you start with the genetic history. And the genetic history is his mother had mood disorder and was treated. He doesn't know what medications. Father was an alcoholic. Then you go into their developmental history. So he had to repeat first grade. And in retrospect, there's some thought that he may have had ADHD, or now, these days, some authorities think that when you see some cases of ADHD, there's an overlap with what there's considered to be childhood bipolar disorder. And in fact, some authorities treat young children with bipolar disorder medications. National authorities, not just someone out in the woods doing something because they have an odd idea. So it's unclear to me whether, and he was never diagnosed as having either, but he had some problems in school, had to repeat first grade. He remembers himself having some troubles when he was a young boy. So he starts out, we have the genetic history, we have his early developmental history, and then we get to the traumas that he suffered. So apparently the father was a tough guy to live with, drinking, difficult relations with the mother. He ultimately had an affair before the divorce. Ms. Lawrence says Ms. Lawrence says he intimated to her that there was one episode of abuse, but I don't know. It's not any further characterized. And then he had a bunch of losses as a child. He was an anxious, depressed child. As a young boy, his house burned down and his dog burned to death with it. There was interactions between the father and the mother that were difficult for him. Father leaves. He's with his mother. He's 12 or 13, and she's dying of cancer and becoming emaciated as she's dying, and he's helping her up the stairs. She ultimately dies. He goes and lives with an aunt. He doesn't want to go with the father and the stepmother. I don't know if she was the stepmother by that time, but anyway, who the father was with, who had moved up to Vermont. And he's living, and for a while he elopes from the aunt in ninth grade or so. Something's happening there, and I don't know the details of that. Then there's some conflict with the father about is Mr. Bourgoin going to have access to the money that he's supposed to inherit from the mother, or is the father going to get it? And it was supposed to go to Mr. Bourgoin as a young boy. Then he ultimately does move up to Vermont. He's a little bit of a stranger in Rutland area. In Rutland, he's not making it socially initially. He's pretty anxious. And then things improve for him because he's very smart. He's a smart man. And he pulls things together. He becomes captain of the football team. But he's still having some problems with the father. He leaves the house, doesn't want to live with the father for a while. I think, and that may have been when there was the issue with the mother's inheritance. I don't remember which one it was as a young boy or in his middle teens. Anyway, he leaves the house for a bit, graduates, but he's anxious. And even before he goes into the army, he's from time to time self-medicating for his anxiety, using marijuana. Then he enlists. He's in the ROTC, or the high school equivalent of the ROTC, before he graduates, and he wants to go in the 101st Airborne and captain helicopters. He's technically smart. He's extremely patriotic. A theme that will come up again when we get to the Colin Kaepernick business, so I'm just mentioning it now. And he wants to go in the Army, and he goes to the Army. He's down south, I think Fort Benning, and he's there for some months, and they discover he has an eye condition called keratoconus, and it's led to him being close to completely blind in his right eye. So so they say, well, you have a medical condition, you have to leave the Army, and that was crushing to him. Then he...
I'm going to stop you there, Judge. I'm noticing it's 15 seconds to 12. Does the court want to...
So do you want to...
This is a good time to break.
This is a good time for break?
Sure.
Okay. So, I know you've only been with us for about an hour, but we are going to take the lunch break at this point. Let's be ready to resume at 1 o'clock. Again, going to continue to ask you to avoid any conversations about the case with each other, any media accounts of the case at all. Just have a great lunch, and we'll see you back at 1 o'clock. Thank you.
Rise, please.
You can step down.
Thank you, Your Honor.
Can I see attorney's sidebar?